Under the Richmond Rent Ordinance, landlords have 8 just causes to evict. In this video, we'll go over the 8 just causes for eviction in Richmond. But before doing so, it's always a good idea to discuss what is not just cause for eviction in Richmond. Sale, transfer, or foreclosure of the property. That's not just cause. The mere expiration of a lease or rental agreement. That's not just cause. Because the landlord doesn't like a tenant. That's also not just cause. Or to get a higher rent on the next tenant. That's not just cause. So what is just cause for eviction in Richmond? The 2 most common types of eviction in Richmond are non-payment of rent and breach of lease. Non-payment of rent means that tenant has failed to pay rent after the expiration of a 3-day notice to pay rent or leave. Breach of lease means that a tenant has continued to violate a written term of a lease or rental agreement after having been warned in writing to cease the violation. 2 other common just causes for eviction are failure to give access and causing a nuisance. Failure to give access means a tenant has continued to deny their landlord lawful entry after being warned in writing to cease denying lawful entry. Causing a nuisance means a tenant has continued to cause a nuisance after being asked in writing to cease causing a nuisance. Some nuisances may fall into the category of serious crimes, in which case there may not be a requirement to warn the tenant to cease the criminal activity. 2 other just causes for eviction in Richmond include temporary termination of tenancy while a landlord makes substantial repairs and owner move-in or owner-relative move-in eviction. With temporary termination of tenancy, a landlord may temporarily terminate a tenancy in order to make substantial repairs necessary to bring a property into compliance with applicable health and safety codes. Landlords are required to pay temporary relocation payments to the tenant, and the tenant has the right to move back to the unit at the lawful rent they were paying when they moved out. An owner move-in or owner-relative move-in eviction occurs when a landlord seeks, in good faith, to recover possession of a rental unit for their use and occupancy as a primary residence, or by the landlord's spouse, children, parents, or grandparents. Landlords must pay permanent relocation assistance, occupy the unit for 36 consecutive months, and provide first right to re-rent to the tenant who was evicted. The last 2 just causes for eviction are withdrawal from the rental market and temporary tenancies. Withdrawal from the rental market means a landlord seeks in good faith to recover possession of all rental units, to remove all rental units from the rental market per the state law known as the Ellis Act. It's important to note that withdrawing from the rental market triggers significant restrictions on the property and the requirement to pay permanent relocation assistance to all displaced tenants. A temporary tenancy means that landlord and tenant agree in a written lease agreement to a temporary tenancy of up to 12 months. This applies only to landlords or lessors of single-family homes and condominiums. Properties must be the landlord's primary residence, and the landlord would not be obligated to pay any permanent relocation assistance. Certain types of just cause for evictions require a written warning notice before proceeding with the termination of tenancy. Before terminating a tenancy for breach of lease, nuisance, or failure to give access, landlords must give tenants a written warning notice. The written warning notice must give the tenant an opportunity to fix the issues described in the written notice, and the landlord must provide a reasonable amount of time of no less than 5 days for the tenant to comply. The written warning notice must inform the tenant that a failure to cure may result in the initiation of eviction proceedings, inform the tenant of the right to request a reasonable accommodation, provide the tenant with the contact number of the rent program, include sufficient details allowing a reasonable person to comply, and include any information necessary to determine the date, time, place, witnesses present, and other circumstances concerning the reason for the notice. Finally, there are special eviction noticing requirements in the City of Richmond. Landlords must provide the rent program with a copy of any notice of termination of tenancy within 2 days of having served the notice on the tenant. Notices of termination of tenancy can be filed online at www.richmondrent.org/termination. For more information about your rights and responsibilities as a landlord or tenant in Richmond, please call 510-234-RENT or visit our offices located at 440 Civic Center Plaza, Suite 200, Richmond, California. You can also visit us online at www.richmondrent.org.